Navigating the legal world can feel overwhelming, but it doesn't have to be. The Indiana Lawyer Podcast is here to help you understand the laws impacting your life, work, and community. Whether you're a legal professional, a business owner, or someone who wants to know how Indiana law shapes the world around you, this podcast is for you. Hosted by Alexa Shrake, a passionate legal reporter, we're here to bring you clarity and insights like no one else can. This podcast is brought to you by Taft, today's modern law firm.
March Madness is nearing its end with Final Four coming up. You may have seen several athletes during the commercial breaks. Name, image, and likeness is a hot topic for college athletes. I sat down with Ice Miller partner Tom Walsh to talk about the newest changes to NIL for Indiana athletes. Listen to hear Tom's work with Purdue University's college athletes. But before we get into it, let's hear from our sponsor, Taft.
Taft, today's modern law firm. At Taft, we cultivate a highly respectful, transparent workplace that fosters creativity, teamwork, inclusion, and diversity. We couple our culture with a client-first approach, rewarding lawyers who understand their clients' goals and work to deliver success. Taft, the modern law firm. To learn more, visit taftlaw.com.
Welcome to the Indiana Lawyer Podcast. I'm your host, Alexa Shrake. I'm here in our Monument Circle studio with Ice Miller partner Tom Walsh. March Madness may be over now, but collegiate athletes are still working. So to start, Tom, can you tell me a little bit how you got involved with name, image, and likeness?
Sure. So the NCAA and related institutions, I guess not really NCAA, name, image, likeness was legalized in 2021. And back then it was kind of a wild, wild west in terms of how it was going to be implemented by universities. But it was the first time really that college athletes had been able to capitalize on the name, image, likeness. Early 2022, I'm a Purdue University alum. And so early 2022, several of us got involved with starting what are called collectives, namely groups of fans and other people who try to facilitate name, image, likeness transactions for athletes at a particular university. And so I've been involved ever since then. Our group is called Boilermaker Alliance, but there's something like us at just about every major institution. And so we're almost 3 years into this, and the landscape has changed, solidified in some respects, but changed quite a bit in other respects. So I'm excited to talk to you about what's going on.
Name, image, and likeness, or NIL, as some people call it. The rules changed a little bit last year as well. Can you kind of explain to me the most recent changes that we saw? Yeah,
so really this is the fundamental change, and really it's going to be finalized on April 7th with what's called the House settlement. It's called House. That's just one of 3 lawsuits that was going on in which athletes challenged the NCAA and member institutions on antitrust grounds. Namely, the member institutions in the NCAA were alleged to be prohibiting athletes from capitalizing on name, image, likeness as they thought they should be able to do. And really, it's. I think the athlete's case is very good in this instance. There's no other person that really was unable to earn a living based on what they were doing or who they were. If you were a famous computer science student or a famous podcaster at a university or what have you, you could make a living doing that if you wanted to. Scholarship athletes, for some reason, were prohibited from doing that. And so it really was kind of an unfair system. Now, the pendulum may have swung way too far in the other direction during the last 3 years as it has been kind of the wild, wild west. But the House settlement is designed to bring some order to that process. And so the House settlement really accomplishes 4 things. First, it sets up a fund to pay athletes from 2016 to 2024 who weren't able to capitalize fully on the name, image, likeness. So there's a fund that will compensate them for kind of lost opportunities, I guess the best way to say that. Second, it sets up a what's I guess normally called revenue sharing model. So for Division I institutions, now this is kind of important, Division I institutions in the 5 major conferences, so the Big Ten, the SEC, the Big 12, the ACC, and what's left of the Pac-12, who are the defendants in the lawsuit, are going to have a fund available to directly compensate athletes on an annual basis. The fund is derived from a formula based on overall athletic department revenues on average from all these institutions. There's about 75 of them that are mandated by this settlement. I think the estimates are that it's going to be about $20.5 million for the first year being July 1st, 2025 through June 30th, 2026. And that fund will be available for all these universities to directly pay athletes for their athletic performance or their athletic participation at the universities. The universities have the discretion as to how to allocate that. And so they can allocate it all to one athlete. They can divide it evenly over every athlete, or what most are going to do is focus on the two main revenue generating sports, football and men's basketball, and then whatever's left over from those sports will be allocated among other athletes. The third component of the settlement is to provide end what are called scholarship limitations on various sports. So sports such as men's basketball and football had they had a limited number of scholarships, but every athlete had a full scholarship. But that was really unusual in NCAA sports. Most sports had, for example, men's baseball had 11.7 scholarships that could be divided among the 30 or so players on the team. So some athletes had full scholarships, some had partial scholarships, and some had no scholarships. And those scholarship allocations could change from year to year. So an athlete might be on scholarship one year and then not the next. It was very confusing and kind of uncertain for the athlete. Now there is going to be put in place what are called roster limitations. In other words, that you can have 34 scholarship baseball athletes if you want. You can have 105 scholarship football athletes if you want. You can have 15 scholarship men's basketball and 15 scholarship women's basketball athletes if you want. So that basically provides additional opportunities for athletes to go to school, have their academics paid for, participate in the sport, and enjoy kind of another financial benefit that was denied to some on somewhat of an arbitrary basis. I mean, if you think about this, if there's 11.7 scholarships available for a baseball team, how do you divide that? It becomes a significant decision for the athletic department, the baseball coach, and so forth. So I think that establishes a much more fruitful opportunity for athletes to participate in their sport. And so the fourth one, which is really the most important one, is that there's going to be a process setting up to evaluate the fair market value of name, image, likeness deals. I mean, when I said name, image, likeness has been a wild, wild west for 3 years, it's because the funds for name, image, likeness have mostly come from boosters, from supporters of the university, either through businesses or individuals. And the athletes' compensation, in some cases, has been truly based on their name, image, likeness, and in some cases has not. So this is really going to be a case where what's called true NIL. So in other words, athlete endorsement of products, athlete endorsement of services, athletes appearing in commercials, athletes making public appearances. Those sorts of transactions, if they're over $600, have to be submitted to a clearinghouse, which will then evaluate them on the basis of fair market value for those services. The hope is that we'll get away from athletes being compensated under the table for things, and really shine a light on what athletes are actually getting paid over and above, as I said, the scholarships and the direct payments from the universities. There's a lot of controversy about that because for years there's been a lot of unregulated compensation for athletes paid under the table, so to speak. And the question is, how enforceable would this really be going forward? I guess that remains to be seen. I think litigation's inevitable in that area, but that's what we're trying to do. What the conferences and the NCAA are trying to do in terms of controlling a name, image, likeness.
So how does this affect student athletes? Do they need their own attorneys to kind of handle this sort of stuff?
Most attorneys. So one of the things that we've observed mostly over the past 18 months or so with the athletes we know from Purdue, is that more and more of them have agents. Some of the agents are attorneys, some are not. Some are family members, some are not. Some are people who really want to get into sports agency, and this is maybe their first client, and they're trying to make a name for themselves. It's kind of unregulated. I think the better known the athlete is, the better the representation from an agent's perspective is. But it's always a question as to whether an agent versus an attorney is a better deal for the athlete. If an agent's taking a certain percentage of all the athlete's earnings, that might be less lucrative for the athlete in the long run than having an attorney you pay for discrete projects by the hour or by the project, whatever the relationship might be. I do think it's important when you're dealing with not necessarily the universities, but when you're dealing with outside businesses whose products you're endorsing, to have representation, someone who knows what they're doing. And here's an example. And this is anecdotal, but I think it's true. An athlete was presented with a well-known athlete in football, Division I football, was presented with an opportunity, but the opportunity would have been exclusive and would have carried forward into his career as a professional athlete, which would have in the long run been limiting in terms of his earning potential. And so having someone who's on your side, who's looking out for those sort of pitfalls and those sort of terms in a contract is always important. So I would encourage any athlete who's approached to endorse a product, endorse a service, or make a public appearance or do something for money, to have someone advising them at least early on as to what they should be looking out for and how they should be thinking about these sorts of transactions.
Have you seen this with any Indiana college athletes?
Well, so, I mean, I'm very familiar with Purdue's athletes, and so I have seen a number of situations where they've been athletes have been really well compensated for their name, image, likeness, and doing projects and doing endorsements and that sort of thing. And I think it's great. I think the athletes they earn a lot of money for the university. I mean, it's interesting. One of the things that stuck with me for a long time. So as I said, I'm a Purdue alum. I've been a Purdue sports fan for a long time. I remember taking my kids to football games when they were little and seeing jerseys for sale there and the jerseys of active players, and realizing because I'm a lawyer and do work in this area in some days, that the athletes weren't getting a nickel from the sales of their jerseys, even though you could see them all the way across the stands, all the people wearing them, and that really is not fair. I mean, that's the athletes. Even though it's the number and their name on the back, it's still their name that the people are wearing, and the athletes should be compensated because it's the athlete's fame that's driving up the value of these jerseys. And the same thing happens today. If an athlete makes a public appearance on behalf of a company or cuts a commercial on behalf of a company, they should be compensated for it. And so I think the athletes who are well known enough or appealing enough to capitalize on that are really should take every advantage of the opportunity.
Is this just for Division I schools?
Yeah, in fact, so the settlement, the House settlement, is just affects Division I. It really just affects. It's just mandatory on the 75 or so schools that are in those 5 conferences I mentioned before. Plus Notre Dame is also included. There's 200 or more other Division I schools though that have a choice to make. They, assuming that this settlement is approved on April 7th, as it's anticipated to be, these schools can choose to opt in or opt out of the settlement. And it's a major financial decision as to whether to do that. Opting in means you are opting in potentially to this $20.5 million or so compensation fund, or some portion of it. You don't have to, not every school has to max out that number. You also are opting into the different scholarship limits, and you're opting into to several other things, and you're opting out of the current Division I structure that you've operated in for so long. I think the Ivy League has already said they're opting out of the settlement, but I'm not sure if any other conferences or any other school has taken a stance on opt in or opt out. So those 200 or so other schools do have a significant decision to make in the next couple of months.
Do you know, is Purdue opting in or opting out?
Yeah, so Purdue's in the Big Ten. It's mandatory for them to participate, and I think that's one of the things that I mean, I'm by nature an optimist, and so I think one of the things that is encouraging to me is that the conferences as a whole, that at least to the extent I'm aware, appear to be collectively in support of this moving forward as a way to level the playing field, make life more predictable for their coaches and athletic administration, and the school administration. And so I think that's is generally viewed positively across the board in terms of conference competition and in terms of again, leveling the playing field for all the schools.
How have you seen universities react to student athletes engaging in NIL?
I think initially there was some trepidation about it. Like, is it going to be a distraction? Is it going to be a situation where you have the haves and have-nots in terms? So you have competitors or teammates, on a very small team, some of which are earning thousands, tens of thousands, hundreds of thousands of millions of dollars. Some are earning nothing. Is that going to affect locker room dynamic? Is that going to be, again, have people wanting to spend more time pursuing NIL opportunities and less time pursuing academics and become academically ineligible and so forth? But I think as this whole thing has evolved, the schools had to embrace it and have embraced it because it is necessary. It's necessary to show the prospective student athletes that you're attuned to what's going on, to current student athletes that you're in support of their ability and opportunities to earn outside income. And so it really has become, in some respects, almost a recruiting, I guess what you might call table stakes, or that you have to have some sort of NIL infrastructure within your school and also outside your school, and then also be supportive of the athletes who want to pursue those opportunities.
Do you feel like this kind of prepares these athletes for when they do graduate and move on into like the professional world, having this?
Yeah, I think it's interesting. I mean, the more exposure you have to business, and this, so I think if you think about Division I athletes, a very, very small percentage of them play sports professionally, and even smaller percentage of those earn income to set them up for life. So it's really of the hundreds of thousands or tens of thousands of Division I student athletes, there's a very small percentage that are going to be professional athletes in a way that really makes them not need to have another job at some point in their future. What I think is great about for the run of the mill Division I student athlete is exposure to businesses, exposure to people who have been successful in life and don't want to have you endorse their product or appear at a company picnic or have some interaction with both them, their leadership, and so forth to kind of give you an idea of what is out there. I mean, it's been a long time since I've been a college student, but I was not at all exposed to situations like that when I was a student. I was not an athlete, but I would have benefited greatly from being exposed to successful business people and would have helped me shape kind of how my career was going to go really early after college.
Where do you see this area of law headed?
So I think it's not litigation is not over. So this House settlement resolves things for the moment. There's a couple of open issues that I think are on the horizon. First, how does Title IX overlay this? So Title IX is the statute that requires kind of equitable opportunities for men and women in Division I athletes, really in all educational opportunities, but Division I athletes is what's relevant here. That's not been resolved at all. So you have, for example, and I'm not trying to predict that this is going to be an issue, but for example, you have this pool of money for direct athlete payments. How is that allocated among men's and women's sports? Are there going to be guidelines? So far there aren't any, but are there going to be federal guidelines for how to do that? The Biden administration issued a proposed rule shortly before they left office, which was rescinded by the Trump administration shortly after they took office. So I think the idea was at least to give this some more time to settle out and see how it was going to be actually implemented before the federal government got involved. So that's one area. The other area is this idea of arbitrating fair market value of various transactions. So what happens if a transaction is denied as being not a fair market value transaction? I would anticipate that should that happen more often, you're going to have another class action suit kind of challenging that regime and whether or not that actually is again a constraint on an athlete's ability to capitalize on their own name, image, likeness. The other area I think that's ripe for litigation potentially in the future is whether this whole scheme makes athletes employees of the university. Right now, everyone's saying that's not what's happening, but there are employment-like aspects of what an athlete is going to be doing now, and should that be challenged? There have been challenges that have kind of been unsuccessful, or at least kind of subsided over time. But should that be challenged, is that going to be someplace where athletes are eventually adjudicated to be employees of the university, not just student athletes? And that could open another Pandora's box of issues for this.
Mm-hmm.
I guess, as I'm thinking about this, there's more things. Mm-hmm. The other challenge here is the House settlement is a settlement of 3 antitrust cases. So three antitrust cases. The question is there is that settlement going to be the last word on whether or not this cooperation between universities and conferences is the same as cooperation between businesses that would be illegal under antitrust law? That again also is kind of something that's going to have to be resolved in the future, probably through legislation. I think college sports, particularly Division I college sports, are really important to the fabric of society in many cases, and it's something where I would not be surprised to have Congress act at some point in the future to kind of let's settle this all once and for all and get back to playing games and having fun and pursuing championships and not worrying about name, image, likeness and litigation and all these things that are really kind of distracting, at best distracting, and at worst kind of turning off the many traditional fans.
You mentioned because I've heard it a lot too, having like these athletes basically be employees of the university, assuming that they have contracts where they sign, like, I'm part of this team. Would it be similar to an employee contract? Or are they also like having to, I guess, like on the financial side of that, W-2s?
So right now the athletes are independent contractors. So they get 1099s, not W-2s. They're responsible for their own taxes. I think every university of any substance has in place financial education programs for athletes, so they know if you get $10,000, that you still have to set aside some money to pay taxes. No one's withholding that from you. You're going to ultimately have income taxes on that money. And I'm not aware. I'm not saying that hasn't happened, but I'm not aware of any situation where an athlete's really gotten over his skis with the IRS on these sorts of payments. I think most of the time they've been well advised to set aside money for taxes and be able to pay their taxes when they come due. If they became employees, they'd be W-2 employees, and that also the income taxes would be withheld just like they are for most of us. They do sign contracts with the universities, so as athletes have signed contracts with collectives throughout this process. Now they're signing contracts with the universities for their share of this revenue sharing pool that each university is going to have. Again, the question is out there, and it's an interesting question. And probably if you were a law student, you could write a nice law review article on this about whether or not they are employees. And you could probably argue both sides pretty effectively, because there's not really any kind of black and white area that covers this situation. So that's one where I think there's going to be something in the next 5 years that settles all of these sort of lingering issues once and for all, because it's just too. The sports are too popular, and they're going to be become less popular and less appealing just if all they do is argue about litigation and different things like that aren't competition related.
Can you tell me a little bit more about the collective, how that kind of works?
Yeah, so the collective exists to provide some name, image, likeness opportunities for athletes. So they're either through marketing services that the athlete provides to charities or other things like that just try to find a way to find the athletes things that they can do that are fair market value opportunities for the athletes to earn a little money outside of the university. And really, the idea, I think, was really to start, the idea was to kind of start the flywheel for NIL within a particular university, because it's been an education process. I mean, like most of the major universities, the universities that are subject to this house settlement, they're in every case substantial universities, a lot of successful alumni, a lot of business leaders among their alumni, and a lot of those business leaders and successful alumni are sports fans. But educating those people as to that this is the new world, that the competitiveness on the field depends on the competitiveness off the field through the NIL program, took some time. But we've at least speaking for our group, been able to generate a number of successful relationships between businesses and the athletes at the universities.
Why do you think sports and college sports and Division I sports have changed so much compared to you were in school or just, 10, 20 years ago?
Yeah, well, I think really the athletes were unfairly prohibited from earning a living based on their name, image, and likeness. It was an unfair situation, and many of them were at the time, and even athletes today are very well known, very popular outside of their just performance on the court or on the field, whatever it is. And particularly if you think about, I big time men's college basketball. Every game's televised. The faces are recognizable. Fans from other schools know who the best players from every other school are, and so there are those folks are very marketable athletes. Football as well. If you're less so, I think, because they wear face masks and they're big uniforms, and so you don't really know what they look like unless you really are pay close attention. But still, if you have a well-known quarterback or running back or wide receiver or defensive end that's very successful and well-known, that person should be able to capitalize on their name, image, likeness, notoriety. That's just what if I was a world famous lawyer, I could capitalize on my name, image, likeness. Why shouldn't they be allowed to do that as well? So it really resolved a situation where they were unfairly, and as it turned out, illegally being restrained from be compensated for an asset that they have.
Whenever we talk about like college athletes, it always amazes me because these are people who are like 18 to like 22, like wild to me.
Yeah, it
very
is.
young.
It is, but they're because of their, particularly the ones who are stars, if you want, for lack of a better term.
Mm-hmm.
I mean, they've been stars since they were in middle school or maybe before. They've been sort of prepared in many cases for the moment because they've done interviews. They've been the subject of newspaper articles. So a lot of them are pretty polished, even though they're 18 to 22 years old. There's some that are also very savvy business people. They know. They look for opportunities. They in fact sometimes generate opportunities for themselves for name, image, likeness compensation, just by hustling and being out there and being proactive. And so that to me is great to see. I love seeing initiative, particularly in young people.
Do you have a team you're rooting for March Madness?
Oh, Purdue, of course.
Yeah. Well, that will do for this week's interview. Tom, thank you again for joining me today. And to our listeners, head over to theindianalawyer.com to read more legal news. Until next time, you can listen to past episodes wherever you get your podcasts.